that was not
Agent, the provision says to accommodate the needs of traditional subsistence users. Doesn't the auction process and the proceeds that flow from the auction process accommodate the needs of the Dion Ginsu?
Okay. The auction process, the purpose of auction process was not calculated according to what the provisions needs. Why? Because even the calculation of the percentage, there was a percentage, 10% for the casino, for the other development issues, but the primary, considering the purpose, the primary purpose of this article was firstly to protect these royal markers. For the auction process, its purpose was not considering what was provided under the Article 3 para 5C. So the auction process violated the rule because that process was not articulated under the provisions of Article 3. Even in connection to the principle of permanent sovereignty principles, in which a state may enjoy and be free and at liberty to benefit his or her natural resources. But once you share these natural resources by two, there is a limited, there is a restriction. You cannot enjoy as you want because not consider other nations and the survival life of these royal markers. So, Your Lordship and Lordship, in submitting class issue number 1, it is our humble prayer that this Honorable Court to declare that the Act of Richmark State is violation of Article 3, para 5C, and they have to stop doing such thing because it was not agreed on. In supplementation, what I'm submitting, I would like to welcome my co-counsel to supplement and submit issues number 2 that has been raised in submission toward the submission. Thank you a lot.
Before you go, did you mention any rule of interpretation?
Yes.
Which article?
The rule does not provide it under the article, but it is a long-standing common rules of language interpretation, which known as expressio unius est exclusio. And I used that rule to supplement what I was submitting to.
I want to know whether you used the plain meaning or purposive rule of interpretation.
Rule of interpretation of this article, I used intention, which a golden rule on looking the intention. What was the intention of that enactment of the law? Because the intention was to maintain and to protect and conserve these royal markers. So I used that methods of interpretation. Also by using that methods, I used the rules of language in interpretation. Because and that rules explain that once you explain something, then there is no any things which has been mentioned under that article. It means we have to exclude such things which have been not mentioned here. And as we can see that even to sell such royal markers, even to conduct a lottery, even to allow a non-foreigners was not written. That is that was not put on the paper. So it means expression of one thing is expression of others. We exclude those things which have not been explained and to consider what was on the paper. That is what I'm submitting to.
I have an additional question. So you are concerned about the royal marker, right? By prohibiting the auction, are you not then, doesn't that then result in a lack of funding for conservation measures? Doesn't it actually harm
the royal marker or conservation efforts for the royal marker?
Conducting auction process.
Yeah, I mean, you don't want them to auction off the right to hunt. But if
they don't auction off the right to hunt, then they don't have the funding to promote the conservation of the Royal Mark Flora. They can't do the research into the vaccine. They can't do the training of the local people. So it is counterproductive to prohibit the auction process.
Okay. Auction process is not bad. But what is bad behind that auction process? After conducting a such auction process, incomes that has been gained in a such auctions does not been calculated effectively. Why? The calculation, because as we consider what articles provides, the primary purpose of a search is to protect and conserve these royal markers. And therefore, you conduct the auction process, is not bad in the eyes of law, but you have to consider firstly the purpose, because even the percentage of conservation of these royal markers was not satisfiable. Only 15% was not enough for the protection by considering what the statute needs. The statute needs firstly to consider conservation of a such royal markers. You conduct a such auction is not bad, but what was the purpose firstly? 30% was not the purpose for the developmental issues, and even 10% was not arranged to develop a such casino center. So the calculation of percentage was not sufficient for the protection. So the auction process was not bad, but what was done bad is only the calculation of a such percentage, considering the purpose of Article 3, Para 5C.
I have one question to you.
Okay.
The Inter-American Convention for the Protection and Conservation of Sea Turtles seems to have a similar subsistence use provisions, and it has been interpreted to permit the collection of sea turtles' eggs. Now,
this that was made in the argument.
How could these indigenous meet their other needs for their survival? By which means?
For their survivals, they may conduct certain activities such as they did for their survivals as they conduct auction processes.
Okay,
Yes.
thank you. Like auctioning, okay, thank you. If that auctioning process is for their subsistence use, as you said,
Yes.
Don't you see that there is no violation since they did this for their survival, and at the same time they are trying to protect these roads to make sure that they are existing. Okay, don't you see that is in the response to that question is that auction process, I repeat again, that auction process, if the primary concern was for the only survival of these indigenous peoples and survival of its own cause, there is no problem with that. What the problem is that who are allowed to conduct such hunting? Who are allowed? Only indigenous peoples were allowed to conduct hunting by using manual weapons like arrows or effectives. So since all these indigenous who were allowed, and in this auction, are they other people who have been auctioning these roads? Yes, of course. Only 10 peoples were allowed who we want the water, and most of the peoples who want water were non-foreigners, were foreigners, were non. My question is, those who auction their rights, were there other tribe indigenous people apart from this tribe who auctioned that right?
Indigenous peoples.
were these indigenous people
Yes.
who had this right to hunt.
Yes.
So it means you will agree with me that there is no such violation of international law.
Since they are the ones who were allowed, and they are the ones who also the right for their subsistence. How many of the new inspector are not appealing you because the transfer of right was not provided? If you transfer your rights, you have to get a permission from other nations whom you share with natural resources. So by transferring the rights, something which was not in the provisions to use the law, because transfer the rights without prior permission or conversation with your neighbor that want to do a certain issue so that they can get subsistence and to survive of this oil. So they did without any conversations, prior permission to other nation or to their neighbor. You are pretty familiar that the act of hunting was for their survival, and this auction process is to enhance their survival as well. Or is your argument of it? The auction process was not only for survival, by the following reason. By looking on the percentage which has been calculated, we have 30%, we have 15%, we have 10%, and another 15%, another 30%. All these percent, as it was calculated, is not justifiable that this percent consider the purpose of these indigenous people and the purpose
of Royal Mako. Why do I say so, Your Lordship and Ladyship? It was not settled under the provision of the law to calculate 10% for casino. That was not on the paper. They came up with their ideas and something which was not on the paper. So it was not to conduct such auctions was not the primary purpose of that article. do all things, but we have to consider what the law says.
Okay, last question. Which percentage among those you have mentioned is not for the subsistence of these indigenous as well as Royal Mako?
Okay. We have 10%, which was delivered for casino, development of casino center. Does that relate to subsistence or Royal Mako? It means the answer is big no. Did we agree to calculate 10% for casino center? Does that relate to subsistence? Does that relate to, say, the protection of survival of this Royal Mako? Only that. You may take as an example that even the calculation was not considering the provision of Article 5, para 5C.
Okay, thank you.
It's my pleasure to represent this submission before you, before this honorable court. But before I draw you to our very own submission, I would like to remind you that our confinement leading to this dispute is centered on two legal issues. And the first issue is whether the trophy hunting of the Royal Mako through the auction process by the hunters who are not Dion Jinsu violates or complies with the convention or international law. And the second issue is whether the ban on importation of Royal Mako hunting trophies violates or complies with the convention or international law and not otherwise. So this will be the issues that we will be submitting. Are they the issues in dispute only? But reminding you that right is not a commodity which can be merely sold or auctioned in the market like an onion. So starting emphasizing on the convention which these two parties, which these two countries are parties that Asta and Dishmark are parties to the Convention on the Conservation of Migratory Species of Wild Animals. So this convention binds these two countries. And then Asta and Dishmark are parties to the Convention on International Trade in Endangered Species of Wild Fauna and Flora, and it is binding upon them, bearing in mind that Asta and Dishmark are parties to the Asta-Dishmark Trade Agreement, which is also registered and binding upon these two countries. Okay, I would like to be very pointed for confining to the basis of our argument in connection with the issues that are before this honorable court. That on the first issue, our submission will be based on the following argument. First is that the Royal Mako are entitled to receive the highest level of protection in connection to the fact that these Royal Mako, they were only allowed to be hunted by the hunters who were Dion Jinsu. Therefore, allowing the hunting of this Royal Mako by other tribes who were not Dion Jinsu violated to the convention that I mentioned prior, which binds upon these two countries. First is that Article 3 of the Convention on the Conservation of the Migratory Species of Wild Animals provides to the extent that the parties are the range states of migratory species, and the Royal Mako shall be protected from being taken except for the exception which has been provided under this article, reminding that the national laws of Asta strictly prohibit the taking of the Royal Mako, as well as the laws of Dishmark also prohibit the taking of this Royal Mako by non-indigenous, by non-indigenous to refer the Dion Jinsu. So it is the laws of the Asta ASA, as well as the law of Richmond, as well as the Convention on the Conservation of the Migratory Species of Wild Animals, all of them strictly prohibit the taking of this royal mackerel by the persons who are not indigenous or the Dion Jinsu bats, reminding me that in this punishment, every right is exercised in accordance with the procedure, even if the law would expressly allow the selling of this light or the transfer of this light, but it would set out the procedures. So, the laws clearly outlines that it is the only Dion Jinsu community which is allowed to take this royal mackerel, but to the extent that there is a provision, when you refer to this provision of Article 3 of the Convention of the Conservation of the Migratory Species of Wild Animals, the convention, the proviso under this provision provides very clear that even these exceptions as provided under this Article 3, they are exercised in a circumstance that, I would like to take liberty to reproduce this proviso, Your Lordship and Your Ladyship, so that I would be well captured. The proviso provides to the extent that, provided that such exception, the exceptions referring to the exception which allows the taking of this royal mackerel, you may refer to the provision which provides that, provided that such exceptions are precise to content and limited in space and time. Such taking should not operate to the disadvantage of the species. I would like to invite Your Lordship and Your Ladyship that you may look upon the provision of this Section 3 of the Convention on the Protection of this Migratory Species, that you may look that even the exercise of these exceptions which allow the taking of these royal mackerels, they shall be not operating to the disadvantage of this species, but when you refer to the way these non-indigenous, apart from the indigenous of the Dion Jinsu community, they exercised this light into the disadvantage of this royal mackerel, which implies that it is in the violation of the conventional international law. I would like to stress,
Agent, if I may ask.
Yes.
If we assume that take of 10, just 10 individuals a year is sustainable, how does that disadvantage the species?
As I said prior, every right is exercised in accordance with the procedures as set out by the law. So, this taking of this 10 royal mackerel by these non-indigenous, it was as against what was agreed in the convention. So, even a literal violation in the law, it implies the invalidity of the action which has been made is as in against of the law provides. So, it is in the disadvantage of the species in the fact that these royal mackerel, they were only allowed to be used by this community of Dion Jinsu and Dion Jinsu only and not otherwise. The non-indigenous were not allowed to take this royal mackerel as per the provisions of the laws requires. Your Lordship and Your Ladyship, again, I would like to submit on the fact that the sale of the hunting light through an auction falls on the commercial side of the line, which violates the conventional international law. As I said prior that this Dion Jinsu used it to sell their hunting light to these non-indigenous, and reminding you that prior I said that light of the person is not a commodity which can be sold and purchased in the auction or in the market like an onion. So you cannot sell your light as an onion or as a tomato before the market. So the light is not a commodity which is not subjected to be sold or to be purchased. And reminding you that the article of the Convention on the conservation of migratory species of wild animals, which is binding upon these two parties, specifically the provision of Article 3, Para 5 of this convention, points out that the taking of the royal macaw is only permitted in special circumstances. In special circumstances, reminding you that the provisions provides the exception as to the taking is maybe for the purpose of enhancing the propagation or survival of the affected species, taking for the purpose of enhancing the propagation of the survival of the affected species, but also the taking is to accommodate the needs of the traditional subsistence users of such species. I would like to invite you, your lordship and your ladyship, to look and examine the provision at its full effect, to recognize that what I am saying is in compliance with what the provision of these laws of this convention provides. So these non-indigenous, out of the indigenous of the Sioux community, they were strictly prohibited by the convention as well as by the laws of the land to hunt. So the selling of the lights of hunting lights by these Sioux community to the non-foreigners, it was falling under the commercial line of the business, which on the other end implies that they violated the convention international law. Submitting on the second issue is that setting aside 15 for the conservation purpose does not satisfy the requirement of the convention on the protection of this species, on the fact that paragraph 5b of this act, of this convention, provides for the primary purpose of taking, whereby the primary purpose for taking must be for the enhancing the survival of the species. But when you refer to the distribution of even the percentage on the profit which was gained from this auction, you will find out that the distribution for the conservation of this was very little compared to the distribution in the other aspects, of which the primary purpose was for the survival of this royal macaw. So even this distribution of this percentage on the benefit which was gained from the trade, it was against as per the requirement of the law, as the main purpose or the primary purpose was not considered, as you may found that only 15% was set for the conservation of this royal macaw, while it is the primal purpose for the conservation of this species. So it would be better maybe if 50% of the advantage which was gained could be set for the conservation of this species, as it is the primary purpose of what the convention outlines. So setting aside 15%, it clearly outlines that it is in violation, total violation of what the convention of international law provides. Drawing you to my very own conclusion, before drawing you to my very own conclusion, I would like to be very pointed, reminding you that what which is clear is stated in a very brief manner, that the paragraph 5, subparagraph C of Article 3 of the CMS offers no justification for the taking of the royal macaw by non-traditional users. But again, on the issue of banning the auction, which violated the convention of international law, my lord and your ladyship, it is our humble submission that the banning of this auction for selling, for auctioning this royal macaw was as in accordance with what the law provides, as referring to the extent that the primary purpose of this convention was to protect these royal macaws, as they were endangered species, and they were in the critical situation that they would be disappeared from the Earth's surface. So the enactment of the banning, the establishment of the banning of this royal macaw, of the banning of this auctioning of the rights of this hunting trophies of this royal macaw, it was in accordance with the law, as the law requires the highest level of protection of this royal macaw. So the banning was in the contemplation, in the contemplation of reserving or as among of the approaches to reserve these royal McCalls as the law requires. Your lordships and your ladyship, if it may pleases you, it is our humble prayers before this honorable court that first, if it may pleases you, give an order abolishing the trophy hunting of the royal McCall through the auction process as it violates the convention of international law, as I have submitted before you, your lordship and your ladyship, that this process as it is in the violation of the convention of international law, as well as your lordship and your ladyship, it is our humble prayers before this honorable court that you bless the ban. You bless the ban that we have established on the importation of the royal McCalls hunting trophies as it is in compliance with the convention of international law. It is our humble submission, your lordship and your ladyship, that you allow and grant our prayers as we have prayed that the practice of auctioning these lights for hunting these royal McCalls, it has to be abolished, as well as blessing the initiative that we have established in the protection of this royal McCall, that we have to, you have to bless the ban on the importation of these royal McCalls as it may please your lordship and your lordship. It is our humble submission.
Agent, with respect to the trade issue, what is the relevance, if at all, of CITES, the Convention on Trade on Endangered Species?
How does that play into the analysis? So the Convention on International Trade of Endangered Species, on the one hand, it says that a country, let's start off with basics. The CITES allows the trade of endangered species with proper permits, right? So how does CITES affect the issue of Astor's ban on the importation of trophy hunting?
Reminding you that Astor and Richmark are parties to the Astor-Richmark Trade Agreement, which, among other things, this agreement outlines some of the agreement between these two countries, and the major confinement of this agreement is on the protection of these royal McCalls, which on the other end that this royal McCall is among of the endangered species. Therefore, this agreement was set to in contemplation of protecting this royal McCall from being disappeared. That is why we are saying that the auctioning process which is done by Richmark, it is in violation of these treaties, as the treaty referring to the major aim of this treaty is to protect this species from being disappeared and being more endangered.
Doesn't the trophy ban violate your trade agreements with Richmark?
Yes.
So one of the issues is, so Astor has banned the importation of hunting trophies.
Yes.
And that seems to be a direct violation of your international obligations under the trade agreement with Richmark.
The banning, it is among of the initiative which is taken from the agreement which we entered between Astor and Richmark, and the agreement among things provided to the extent that the major or the primary purpose will be protecting these royal McCall from being disappeared. That is why the initiative of banning the importation of these hunting trophies, it is in the contemplation of protecting these royal McCall from being hunted as vigorously as they wish, so that the hunting shall be as in accordance with the law. So when you refer to the primary purpose of the agreement which was entered between Asta and Richmark, you will see that the major purpose of this oral agreement was to protect this royal McCall. That is why the state of Asta has established, as among other things, the initiative of banning the importation of this royal McCall, so that to protect the number of this species, which is, among other things, it is in the critical condition of being disappeared from the world. So the primary purpose of banning the importation is to protect this royal McCall from being hunted as vigorously as these the Richmark wishes, which is in violation of the law. So the banning as an initiative that Asta has made, it is in compliance with the conventional international law, as it aims at protecting these royal McCall from being hunted as vigorously.
So is your argument on the trade issue that the ban on the importation of trophy hunting is justified under Article 20G because it is related to conserving
exhaustible natural resources?
The banning is allowed and justified in the laws, in the conventional international law, and in the conventional international law, as well as the trade agreement which was entered between these two countries. That is why we are saying and we are emphasizing that the banning is in compliance with the law. That is why we are praying before this honorable court. So
to brace the banning as it is in the contemplation of protecting this royal McCall from being disappeared.
So are you making the argument that you're justified based on public morals?
Yes.
Could you elaborate on that, please?
As we said prior, our confinement for the issue of dispute before this honorable court is on two issues: whether it is basically on two issues.
I said prior that the first issue is whether the trophy hunting of the royal McCall through the auction process by the hunters who are not Dion Jinsu violates or complies with the conventional international law, and we said that the hunting of the royal McCall through the auction process violates the conventional international law, and we demonstrated to the fact that it was as per adventure. And on the second issue, that as to whether the ban on the importation of the royal McCall hunting trophies violate or complies on the international law, and we said and we demonstrated that the ban on the importation of the royal McCall hunting trophies, it is in compliance of the conventional international law, as all these aims at protecting these royal McCalls so that they will exist even for the future, so that they can be like the heritage of the world. So that is our aim, protecting this royal McCall from being endangered, as the acts of the Richmark, they are totally in contemplation of even making these animals to be at the very, very, very critical condition of being endangered. That is why we are urging before this honorable court, your lordship and your ladyship, that our prayers be granted, so that for the benefit and for the protection of these royal McCalls.
From the fact, it is clear that Richmark took initiative to protect the royal McCall.
My lord,
Because they were allowed, the only those indigenous people were allowed to take only 10 royal McCall per year.
you are right.
So it means the Richmark was taking initiatives to protect this fish.
You are right. just hiding around the bush. Their activities are like they are looking like they are taking initiatives to protect this royal, but in fact it is not, and it is big more. They are taking it as just
a bush to hide their bad activities, as you may refer to the distribution even of the benefit which is gained from the auction process. You will find that.
Just listen.
Yes.
I was not done. I'm not done. So by being allowed to take only 10 animals, 10 individuals, and considering that there are about 2,000 something individuals of the species, and they reproduce. So by taking 10 these indigenous people, there was no harm. The fish was protected, was being protected, because only 10 per year. So there was no harm. The producer was taking 10 individuals. What is the difference now? If the individuals are allowed to take 10, what is the difference? What is the matter if these 10 individuals were taken by auction?
Yes, I would like to remind you that the exception that even this
In Sioux, they were only allowed to take this under special circumstances. When you refer to the proviso of the provision of Article 3, Paragraph 5 of the Convention on the Conservation of the Migratory Species of Wild Animal, you may look and invalidate the peradventure of the provision which provides under the proviso that provided even the circumstance under which the exception will lie shall not operate to the disadvantage of the species. Even the Dion Ginsu, they were only allowed to take this royal macaw if it was not on the disadvantage of the species. So even the taking of these non-indigenous 10 individuals, it is on the disadvantage of this royal macaw, as it is in violation of what the provision of the laws provides as the major purpose. And reminding you, your lordship and your ladyship, that the major purpose, the major confinement of the agreement which was entered between these two countries, it was on the protection of this endangered species.
Can you please read the
yes,
first issue?
I may read.
The first issue.
The first issue,
yes.
the first issue that is on dispute between this, before this honorable court, is that whether the trophy hunting of the royal macaw through the auction process by the hunters who are not Dion Ginsu, by the hunters who are not Dion Ginsu, violate or comprise with the conventional international law. But I draw you to the proviso.
Okay, listen. So the issue here is the hunting by these foreigners. Yeah. So I'm asking you whether if 10 individuals were taken by Dion Ginsu, there was no problem. The problem is the species being taken by foreigners.
I would like to remind you, as to what I have already prior submitted, that even the Dion Ginsu, they were only allowed to take the royal macaw in a limited exception, as you may refer to the provision.
10
only 10, but it was not compulsory that they took 10, as you may look at the provision which, under the proviso which provide that such exception are precise as to the content. The exception that this Dion Ginsu shall take, such exception is precise as to the content and limited in space and time. Such taking should not operate to the disadvantage of the species. And I invite your lordship and your ladyship to take full consideration of the proviso under this provision. You will find that what I am urging, it is in compliance with what the law says. Even the Dion Ginsu, they were only allowed to take this royal macaw in exceptional circumstances. So you will find that there are circumstances that these Dion Ginsu, they will not take 10 if the circumstance permits. So the taking of these 10 was in accordance with the circumstance, which will occur, as you may refer to the provision as it provides, your lordship and your ladyship. That, and I would like to remind you that this provision of this provision of Article 3 sub 5 shall be read careful when in the position to interpret this provision. You have to read it very careful, that the proviso provides to the extent that even the exception which allow.
I'm sorry, Councillor. You just have to answer question. You are okay. What was the ban all about? What was banned?
The ban was to ban the importation. The ban was to ban. The ban was on
the importation
of this royal mackerel.
Not the hunting.
Let me read it clearly so that we can grasp a very and clear meaning. I will take liberty, your lordship and your ladyship, to repeat on the second issue that whether the ban on importation of the royal mackerel hunting trophies, violates or complies with the convention, international law. And we said yes, the banning, it is in compliance with the conventional international law, as we have demonstrated in our submission beyond para-adventures.
So do you think only the importation of this, the trophy, only importation, can it have any impact on preventing this species from being endangered? What if the Dionjinsu would come back to their old ways of using the species?
As to the totality of our submission, your lordship and your ladyship, is that the banning of the importation of the royal mackerel hunting trophies will, on the other hand, implement and initiate to protect these royal mackerel, and reminding you that the proviso under the Article 3 provides to the extent that even these Dion Ginsu were only allowed in limited circumstances, so it will not be easier that the circumstance will allow them to every year hunt 10. So there will be a time that the circumstance will not permit them to hunt 10, which will, on the other end, improve the protection of this royal mackerel.
Okay, I need a yes or no answer. So if the Dionjinsu decide to go back to their old ways of using the trophy for traditional and religious purposes by hunting only 10 individuals, would it have any impact to the population of this species?
As I said prior.
Yes or no?
Allow me to elaborate, please. As it is the court of justice, it is the court which allows the interpretation of these laws as to the para-adventure.
You start with the yes or no, then you give the reasons.
Let me say they will be hunting, that is yes. After hunting, but the hunting will be in accordance with the laws. As I said prior, that even this Dion Ginsu, they will be only allowed in limited circumstances to hunt this royal mackerel. So unfortunately, it will not be 10. Maybe as the circumstance maybe will allow, maybe 2 of them will be hunted, as depending to the circumstance. Maybe, takes an example, if they want to hold only a single ceremony in the year, automatically they will hunt only 1, and the 9 will be reserved. Automatically the species will be protected.
Okay, I have a few questions. You said that your focus is on banning exportation.
Banning importation of royal mackerel hunting trophies.
Importation of?
Of royal mackerel hunting trophies.
Okay. My question is, what percentage or percent of royal macaws these giant jinsu were allowed to hunt according to the instrument you have cited?
They were allowed to hunt only 10 loyal macaw.
Okay. Only 10.
10 loyal macaw.
Okay. Did that consider the number or increase of these indigenous?
That is why we are submitting that. This Dione Ginsu, it was not limited that they shall hunt 10 loyal macaw, but they will hunt in that number if the circumstance permit. That is why I said prior
if
that
the circumstance
will permit.
Which circumstance do you think?
That is why we say that we shall refer to the provision which allowed these.
Okay, another question is, they auctioned how many royal macaws?
10 loyal macaws.
10.
Yes.
So if they had the right to hunt 10 and they auctioned the same 10, let us now come. You have said, if I've got you, that right cannot be sold, isn't it?
Yes.
Okay. Which right are you referring? Right to own or right to use?
The Dion Ginsu, they had a right to hunt.
Understand the question. Stick to the question.
Yes.
Listen carefully to my question. You said that right is not a commodity and cannot be sold, isn't it?
Yes, Your Lordship.
Which right were you referring? Right to use or right to own?
Right to use.
Right to use. For instance, if maybe I have a right to use maybe this room, and I'm not in a position of using it, if I sell that right to another person for use, is it allowed or not allowed in the eyes of the law?
In the eyes of the law, it is not allowed on the extent that every right is exercised in accordance with the law. If the law sets out the right, automatically the exercise or the utilization of such light shall be as in accordance with what the law provides. If the law has provided that you may use this room, maybe providing some circumstances under which you will not use, automatically you will have.
Okay, understand my question.
Yes.
Means that if I'm transferring the same right, can't I transfer my right?
It depends on what the law provides. If the law allows you...
Does the law allows any person to transfer his right or not?
The law, it depends. For instance, maybe.
For instance, I have this campus is my own.
Yes.
Is my?
Your own.
My own. Am I allowed to sell it or not?
You sell a company and not your right.
Not my?
You are right.
What about my right to own this campus? After selling, have I sold that right or not? Right to own this campus.
That is a proprietary right. If it is the proprietary right, you can do it, but in accordance with what the law provides.
Yes, the law is there. The law is there.
Yes.
If I have transferred my right, the property goes with the right to attached to that property, isn't it?
Yes.
So, are you still sticking on your argument that the right cannot be sold?
Yes, I do.
You do?
Yes.
Okay. You said that they sold the same amount which they were allowed. Did they exceed the limits which were set in that particular instrument?
They exercised their right, but in ignorance with the proviso which given them the right, whereby the proviso given
My
them the
question
right.
is, did that amount of royal macaws which were auctioned exceeded the amount which was allowed to be hunted by these indigenous?
In accordance with what the law provides, automatically it exceeded as the circumstance did not permit them to do so.
I'm asking about amount. Did it
Yes,
exceed?
it exceeded as the circumstance did not permit them to do so.
Remember on your first argument, you
Yes.
said that they sold the same amount. Why now are you turning hostile on what you argued previously?
I'm not turning, but I'm emphasizing that every right shall be exercised as in accordance with what the law provides. We have a provision which gives you the right, but on the other end takes that right if you are not in exercise of the laws. The laws allowed them to exercise that right, but in special circumstances. And I invite your lordship and your lordship to examine the full effect of the Article 3, sub 5, specifically the
Okay,
proviso.
my last question. If the instrument allowed hunting of 10 animals and the same amount is hunted, does it decrease the amount of royal macaws there?
It decreased on the ground that the law allowed them to do in a special circumstance.
Okay, thank you. Thank you.
Now, what are your prayers before this honorable court?
Your lordship and your ladyship, it is our humble prayers that our prayers be granted that first, if it may please your lordship and your ladyship, give an order abolishing the trophy hunting of the royal macaw through the auction process as it violates the conventional international law, as we have demonstrated para adventure. Secondly, bracing the ban on the importation of the royal macaw hunting trophies as it is in compliance with the conventional international law. And if it may please your lordship and your ladyship, grant any other order that this court may deem fit and reasonable to grant.
So you are praying this honorable court to apply the strict law, is it?
Yes.
Now, those strict law has general rule and exceptions, is it?
Yes.
What are the effectiveness of those exceptions of the law?
As I said prior, that the basis of our dispute between we, the state of Ulster, and Richmark is on the interpretation of the provision of Article 3.
My question is, what are the effectiveness of the exceptions of that general rule? Effectiveness.
The effectiveness is that if you will allow our prayers, automatically we will encapsulate the aim of enacting these laws, as these royal macaws will be protected as it requires the highest level of protection as the conventional international laws provides.
So you are saying this law is a bad law?
It is not the bad law. That is why we say that our prayers are in compliance with the conventional international law. And we have demonstrated through para-adventure.
Now, if you are saying that is a good law, is it?
Yes.
The strict law.
Yeah.
How does auctioning affect the growth or increase of those royal macaws?
As I said prior, the exception operated under special circumstances.
How does auction affect the growth or increase of those royal macaws?
Yeah.
That's my question.
Yeah, your question, I will answer it as follows. The royal macaws were entitled to be hunted in special circumstances as the law provides. But when you refer to the auctioning process, all 10 were hunted without even inferring to the circumstance. So they were in violation of what the law provides. The law provides that you will hunt the royal macaw.
Along the law, go to your thinking. How does it affect?
It affects on the circumstance that I will not depend on the law. Maybe if the circumstance permit, the Dione Ginsu maybe have only 2 ceremonies per year. Automatically, they will only hunt 2 royal macaw. But the auction involves all 10, even without inferring to the circumstance. That is why we are praying before this honorable court that our prayers we are sought be granted, so that to the protection and to the best of this royal macaw, even for the future generation between these 2 countries, that is Asta and Irishmak.
Now, how can it be conservated? Because there are some percents which are used for conservation purpose after being auctioned, is it? Now, how could it be conservated after these indigenous people being lack money for conservation?
We have the social science principle of ecology, that the nature itself knows how to conserve itself. So, the ecological balance will determine the growth of these royal macaws. So, if this auction process will be banned, will be declared null and void automatically, the ecological system will determine the destiny of this royal macaws, so that they will increase in number, as there will be no compulsory hunting as it is done under the auction process.
Okay, thank you.
I have one question to ask you for clarification. Between hunting by the indigenous and hunting by these auctioneers, which one is the best in preserving the royal macaws? The reason behind asking this question is that hunting by indigenous had no any percentage in return. After hunting these 10 royal macaws, had no any percentage of preservation of royal macaws. But coming to the hunting by these foreigners has some percentage of preservation. And another addition is hunting by these foreigners to some extent improves subsistence life of users, these indigenous. Which one between these 2 is the best option between these 2? Hunting by indigenous and hunting by these foreigners. Which one is the best?
Hunting by indigenous is the best on the ground that we have the concept of ecological balance, and the law allowed them to hunt in a certain circumstance. Ecological balance. Yes.
Are they hunting which amount of royal macaws?
They are allowed to hunt them, but depending on the circumstances.
How many?
10 depending on the circumstances.
These foreigners?
They are hunting 10 without even looking to the circumstances.
10, okay. But hunting by indigenous has how many percent of preserving these royal macaws in return after hunting? How much percent in return?
In return, I said that there is ecological balance.
Is there any percent in return after killing these animals? Did they have any percent on how to improve these royal macaws?
Your Lordship and your Lordships, as I draw you to our very own submission that there is the concept of ecological balance. That is why I said prior that if they hunt 2 but this hunt 10, what is the best?
Which balance are you talking about?
I am talking about that the Dion Ginsu in the genus community, they were only allowed to hunt this.
We are coming to the ecological balance.
Yes.
Which balance, ecological balance, are you talking about?
The ecological balance I'm talking about is that these Dion Ginsu, specifically, naturally, they were related to the royal macaw. That is why I am submitting to you, your Lordship and your Lordship, that these they hunted in special circumstances. Maybe they would hunt 2 of them, 2 of the royal macaw, but these they will hunt 10. It is compulsory that they hunt 10. So automatically, those who hunt 2 and left 8, which is the best maybe, automatically those who hunt 2 and left the 8, as depending on the circumstance, will be the best to the development of this royal macaw. And I may refer you to the population growth of this royal macaw.
Okay, apart from food, when indigenous were hunting, apart from food, did their hunting increases healthy care?
Healthcare?
Yes, for instance, buying medicine. Did their hunting, the effect of hunting, had any contribution
as we said,
to their healthy care, for instance, medicine?
As we said prior, the primary purpose was for the protection of the royal macaw and not otherwise. That is what
you talked about ecology. Let me ask you about ecology.
Yes.
Okay. You know, even hunting is, nature balances itself through, because those royal macaws were being hunted.
Yes.
And when, after every successful hunt, the meat was always shared with the villagers.
Yes.
So don't you see also that is ecology? Because we eat that, the villagers eat that, those animals. It is also for subsistence use.
Yes.
And it's still, it is, nature balances itself.
Yes. That is
so
why.
What's the problem?
So that is why I have said that the abolition of the hunting by these non-indigenous, that is why we are praying before this honorable court that they shall abolish the hunting by these non-indigenous. As you refer to the ecological systems, that is why the only Dion Ginsu were allowed.
Okay, thank you very much. Another side of the bar.
Thank you, Honorable President. Before you, for the matter of records, my name is Amani Michael Kinyamagoa from TZ 011. I'm a leading counsel. I'm accompanied by my fellow co-counsel, George Mosh. On this matter at hand, I will be required to use 30 minutes. For my side, I use 15 minutes, and the other remain 15 minutes used by my fellow counsel. Honorable President, under this case, there are 2 main issues. For my argument, I will be focusing on the first issue, that whether the trophy hunting of royal macaw through the auction process violate or comply with international law. From our argument, I will be focusing on that the auction process is not violate international law, but it comply with the international law on the basis that the fund which collected go direct for the conservations of these endangered species, but also on the subsistence use that to accommodate the needs of the community. Honorable President, with due respect, I would like to remind the applicant side on the fact that in 209, after that Loyal Makul be added on CMS in Appendix 1, where B required this Dion Disu only 10, hunting only 10 Loyal Makul, but also for this Weiner of bites were required to hunt only one Loyal Makul with support to the guider from the Dion Disu community. Honorable President, on matter of my argument, I will be focusing that I would like to remind this Honorable Court that Richmark is a state. On basing on that, under the International Montevideo Convention on the Law of Treaties, Montevideo Convention in the Rights and Duties of the State of 1933 provide 4 criteria that in order a state to be a state must comply with it. That to have a permanent population, defined territory, must have the government to get the capacity to enter into relation. In our relation that Richmark is a state. On remind on that Richmark as a state have the sovereignty of the state. This has been emphasized on the provision of Article 1 of the draft declaration on the rights and duties of the state of 1949. Under this, provide the right of the state on enjoyment of their resources, but at exercising their function without interference of any foreign country. Also, under the provision of Article 2 of United Nations Charter, provide that the state have the right and other state cannot require it to interfere the internal matter of the other nation. Honorable President, in relation to our matter, the action done by the ASTOL is trying, whether direct or indirect, is trying to interfere our internal matter of our country. Honorable President, under this, I will argue on the principle of permanent sovereignty of a natural resource, which under this principle has been stipulated under the General Assembly Resolution number 1803, square bracket 17 of 1962, which under this provides the principle of permanent sovereignty of a natural resource, that the states have the right to use and enjoyment their own resources without interference of any foreign state.
Agent, yes, that may be true. I don't think anyone is disputing the sovereignty that Richmark has over the Royal Marcour in its territory. But Richmark has signed a treaty, a convention, the Convention on Migratory Species, that then limits its right or obligates it to refrain from taking or authorizing the taking of Royal Marcour. So the state may have the sovereignty, but it has willingly given away some of that sovereignty when it signed the Convention on Migratory Species. Did it not?
Thank you, Honorable President. Under the provision of Article 3, Sub 5, B and C provides the general rule of taking of these endangered species, but also provide an exception on that the taking as permitted on these endangered species only on the enhancing survival of such species, but also to accommodate the needs.
Did you understand the question?
It may please you. Can you repeat?
So my question had to do with, you were speaking about that Richmark has the sovereign right to do what it wishes with the Royal Marcour. But also, as sovereign, Richmark entered into an agreement that obligates it to protect the royal markhor. So the sovereignty argument seems to be a bit of a side issue. And so what I would like you to address are the exceptions in Article 3, as I think you were about to do.
Honorable President, under this permanent sovereignty of a natural resource, this, as you see that Loyomakul is owned by two states, that Astol and Lishmak. On the applicability of such, on basing by this state, on required, on depend on the legal circumstances of each particular case. In our case, that these two states have the right on making utilization of the development of the resources, but also on economic sovereignty, and have the duty to prevent these endangered species. Honorable President, on making my argument, I'll be focusing on the case of Libya American Oil Company, Liamco, versus the government of Libya Arabic Republic, the case of 1981. Under this, the court held that all the states in exercising their right are free use and exploit their waste and natural resources. But also, they are needed to maintain the flow capital condition of security, mutual confidential and economic cooperation among the nation. In relation to that, the action done by Astor is trying to violate our right of enjoying to use this royal makul, but also on making the development in our state. As you see that the Rismark is the state which have the proverb. Therefore, they're trying to make different efforts that can help them on making or on increase the capital of the state. Honorable President, under the provision of Article 26 of United Nations Declaration on the Rights of Indigenous People, has provided the right of indigenous that have the right to control and manage their own resource, but also have the right to make self-determination and also have the right to consent. And this has shown in relation to our case that the Richmark government respects this indigenous right. On that, at the through auction process, the indigenous are meant to have their right of hunting, but also the Richmark government use for the winner of bids who are required to hunt one loyal makul, they are be supposed to have the guide from the Diondusu community. This shows that these rights of indigenous are being respected to our nation. Also, under the provision of Article 23 of International Covenant on Economic and Social Rights, under this provide that these indigenous people have the right to hunting. Honorable President, I would like to emphasize or to argue on the subsistence use, which this has been stipulated by the different laws under the CMS that Conventional Conservation of Migratory Species permit the taking which are under Appendix 1, that the law permits only taking for the circumstance that to enhancing survival of such species, but also traditional subsistence use. On that, on enhancing survival, as you see that one among the percent collected through the auction process was gone on conservation of these endangered species, which is 15% of the fund collected under the auction process. Also, Honorable President, under this, to accommodate the tradition of, or to accommodate the tradition of the community, as you see that the meat which be collected through the hunting was being divided to the Disu community. And under this, that the fund was divided to be used on the food, clothing, and medicine. Honorable President, under this has also been shown on the site is that the purpose of site is that site is called the Convention on International Trade in Endangered Species site. Under this, the object of this, the species which provided in Appendix 1 these species are be only permit on the exception circumstances. That the first one is be permitted for the conservation of such species, but also to accommodate the need of the society concerned. Honorable President, on that has been that under the CMS provide the subsistence use on a favorable conservation status, that the use of such species cannot impede the recovering of such species. As you see that one among the 15% has been go to the conservation of this species. That means the Richmark state try to prevent these endangered species that cannot be extinct to their territory. Also,
Agent, could you respond, please, to Astor's assertion that 15% being set aside for conservation purposes is not sufficient to fall under to qualify for the exception?
Honorable President, on reply to your question, is 15% better than nothing? That 15% help on the conservation is better than the nothing on making effort on the conservation of such endangered species. Honorable President, under this, with due respect on that, I will concur with the argument presented with the applicant that the auction process has been the primary purpose, that to protect the survival of species as provided at Article 3, Paragraph 5, B and C, that the 15% has been gone for the conservation of these species. But also the auction has been go on the limitation for subsistence use. Therefore, these Astol are tried. The Astol action is gone on violation of this international law. Honorable President, it may please you our prayer on that to declare that the action process done by Richmark is not violate the international law, but comply with it. We have been concurred with the argument of applicant side to provide that one among the funds which collected through the auction process go for the conservation of these endangered species. That to show that the Richmark government tried to maintain the status that these endangered species cannot extinct to their territory. Honorable President, also it may please you, this honorable court, to declare that the transfer rights of hunting by non-engineers comply with international law on basing on the exception provided under the CMS and Article 3, Paragraph 5, B and C, that to accommodate the need of the community has been provided under the right that indigenous people have the right to have the adequate standard of living, that to have food, housing, and good has been shown on the evidence that one among the percent was divided that 30% was basing on the housing expenses, 30% also go for medicine expenses, and 15% for community food expense, and 10 was paid to casino conservation, which under these 10 help us on making the improvement of our auction process that can help us as a Richmark to get more capital to accommodate, which help to accommodate the needs of the society, but also the effort of conservation of these endangered species. I humbly submit.
Starting with your the second exception, which you justify, you use as a justification for taking Royal Macau. The exception, this Article 3, Paragraph 5C, to accommodate the needs of traditional subsistence users. If you read between the lines, you bought the word traditional subsistence user. So what do you understand by the word traditional?
Tradition that to means the norms or cash flow are be believed by a certain community.
So I put to you that by selling the right to use, it is not for traditional use, not for traditional subsistence use.
On that, as being based on the subsistence use, that one on the fund collected go to accommodate the needs of the community of the Ondisu, that can help them to subsistence use. As you see on the fact also that according to this right of hunting, these indigenous have remained their right of hunting and use this Loyo Makul trophy as a symbol of their tradition, also are used on their ceremony. And the meat was divided to the Ondisu community.
That was before they sold their rights. After they allowed these foreigners, there was no use of horns for indigenous people. The horns were taken, right?
Yes.
So it is no longer for traditional uses.
It's also for traditional use because after selling their right, the winner of this auction process, when going to hunt with the guider of the Ondisu community, the meat was remained to the Ondisu community.
So where I don't see any traditional use here. Maybe you can convince me. How was it used traditionally?
I think that they use the tradition that they use this meat to accommodate they required the right to have the food in their community.
Okay. And another exception, it says the taking is for the purpose of enhancing the propagation or survival of the affected species. So you're saying that your country is taking the species for the purpose of enhancing its survival, right?
Yes.
And hunting involves killing. So how does killing enhance the survival of the species?
Honorable President, go to the meaning of taking has been shown under the site also include killing of the animal. That after killing such animal, then is go on the limitation under the meaning of taking, which stipulated under the site together under the CMS.
Okay, and you said that by the ban by Astro, the ban to import, it interferes your sovereignty, your country's sovereignty. Did I get you properly?
I said that on the argument that the banning of Astol is violate our sovereignty, because we are the state, we have the right to enjoy our resources, that for the benefit of the nation, but also for the benefit of the people. This interference that to input ban are trying to interfere our...
Okay, enough. But the ban is only in their country. They just banned the importation of the trophy. How does that interfere with your sovereignty?
Honorable President, under the provision of Article 11 of ALTA, which the bilateral agreement entered between these two states has permitted the import and export of these species. Therefore, the banning were imposed by the Astol violates the international law or the bilateral agreement entered between these two parties.
Now you have explained about subsistence use. Is it traditional subsistence use? Does this include auctioning?
Under the subsistence use did not include the auction, but once the indigenous have the right to use their resources and also have free to enact any reform or policies governing on the enjoyment of their right, and the Richmond government tried to emphasize to enforce such right by input the auction process that can help them on enjoyment their resources for the benefit of nation, but also for the benefit of the community in Lishmak.
So, do you think this honorable court will grant your prayers of violating the law purposely?
Honorable President, it may please you, I would like to pray under this honorable court to declare that the auction process is not violate the international law, but comply with it. Because when you see under the provision of Article 3, paragraph 5, B and C, provide the general rule of permit of taking of these endangered species, but also provide an exception on taking of these endangered species that can permit taking on to accommodate the needs of the community. This show that, but also on conservation of these endangered species. Therefore, this Richmond government tried to institute the auction in order to accommodate this exception provided under the law.
So what are the terms of the contract between these two nations?
One among the terms of the contract between Astol and Lishmark trade agreement is to protect these endangered species which are migrant from Richmark to the Astol, but also from Astol to the Richmark, but also have the purpose to accommodate or to making development that these species help them on making improvement of the nation economy.
And you are talking about permanent sovereignty of natural resource to Richmark, is it?
Yes.
What about the principle of pacta sunt servanda?
The principle of pacta sunt servanda has been explained that once you enter into an agreement, you must respect the term, but also act in a good faith.
How does it applicable in your country?
In my country has been applicable well, because once we enter into an agreement between Astor and Richmark on protection of these endangered species, on that we're starting the auction process, that we think that the fund which collected will help us on making the conservation effort to maintain these endangered species, that to remain to be in our territory and not be extinct.
Okay, and why can't you concede with the applicant prayers of applying strict law? Why can't you concede the prayers?
I'm not concurred with the prayer granted from the applicant side, because in our side we see that there is no any violation of international law. Therefore, there is no need to apply strict law, because in Richmark government there is no any violation. The auction process goes on the exception of international laws.
Okay, thank you.
Okay. I have a few questions. Will you agree with us that these indigenous people, they are not living the way of life they used to live previously? Will you agree with us?
Pardon?
Will you agree with us that the mode of life of these indigenous tribe now is not the same as is used to be previously?
Not agree with you.
Not agree with me. What are the uses of horns now after auctioning the right to hunt?
They are decided to sell that to accommodate their needs.
Previously, what was the use of the horns?
They use horns on their ceremony.
On their ceremony. Are they still using the same horns as they used previously?
Honorable President, I think they are still use such horns, because
you think, a council, you are thinking. Yeah?
Sure.
But in your previous argument, you said that they are not using now, since they have auctioned and there are different uses. Is it correct?
Yeah, it's correct.
Yes?
It's correct.
Correct. If previously, when you entered into this instrument, it was for the use as it used to be, isn't it?
Yes.
Isn't it?
Yes.
Okay. If now the use has been changed, will you agree with me that use was direct use of the products from the royal macaws when you entered into the that protocol, isn't it?
Pardon?
When you were entering into these retreats previously, these indigenous were using direct products from the animals, isn't it?
Yes.
But currently, will you agree with us that now they are not using the products direct from the animals, but they are using money instead of direct products from the animals?
Yes.
Yes. If that is the case, don't you see that there is a serious violation of the law?
Honorable President, in reply on that, there is no any violation under the law.
If there is no any violation, will you agree with me that this tribe now has the similar characters with other tribes who are not under that exception?
The indigenous people have the same character
to other tribes,
yes,
who are not under this exception. If the answer is that, how do you say that there is no violation?
There is no violation because the indigenous people have the right, but on imposing such right, but also have the duties.
Have that, while at the same time you said that these indigenous who were covered under this instrument have lost that character. How now are you turning to say that there is no violation? While you said that they are living the modern life like other tribes. Means that, what about other tribes? If they sell or they auction, do they have that right?
Honorable
other tribes, do they have any right,
yes,
to hunt?
They have.
Other tribes, apart from this indigenous tribe which has been mentioned and covered, have they have that right?
Indigenous,
other tribes,
they
don't have. What about this tribe now which has lost, and you said that it is now they having the same character like these ones?
Honorable President, under the right of indigenous have also the right to transfer their right if they are consented to do so.
Okay, thank you.
Perhaps the last question from me. My colleague had asked agents for the other side about the Inter-American Convention for the Protection and Conservation of Sea Turtles. Does that convention offer any assistance for your argument?
Honorable President, have under this convention have taken the support on our argument has been shown, can be also elaborated on the second issue, if may pleases you.
Thank you.
Thank you. Much obliged.
Next.
Honorable President, here before you is George Nestor Moshi, representing the respondent side on the matter on hand with code number TC 011. Honorable President, having my lead counsel concluded on the deliberation on the first issue, I may now seek to engage on the second issue of whether the ban on the importation of Ramacool trophies complies or violates with the international laws. Honorable President, I may keep engaged and focus on submission on this issue on the following sub-issues. The first, I'm going to make submission on the permanent sovereignty of natural resources, but also I'm going to make a submission on the convention in international trade on endangered species, flora and fauna, but also I'm going to make a submission on trade agreements, also make submission on scientific basis, the principle by the virtue of Article 26 of the Vienna Convention, but also I'm going to make submission of the ALTRA agreement that legally bounded these two nations in 2003. Honorable President, if it pleases you, may I start with my first submission. Honorable President, the principle of permanent sovereignty of natural resources, it is recognized in various international instruments, including the United Nations General Assembly Resolution 1803 of 1962. That affirms the sovereignty of the nation over their natural resources, emphasizing their management and environmental protection. Your Honorable President, this principle of permanent sovereignty over natural resources, its applicability is on the nation entering or adhering to the international legal framework, such as sites that provide legal mechanism for the cooperation between these states sharing the endangered species, requiring them to develop conservative strategies on monitoring species population. Your Honorable President, taking the matter on hand, the Richmark government, it provided some conservative efforts that go hands with the international legal framework, such as the sites that call upon the states to take clear conservative efforts while regulating the trade that was prohibited under sites on the Appendix 1, which listed this royal mackerel as one of the endangered species. Your Honorable President, coming on the matter on hand or making the relative on this matter on hand, the government of Astor implementing this ban on the importation of royal mackerel trophies from Richmark to Astor, it clearly showed that it violated the international legal framework. Example of that legal framework, international legal framework that was being violated by the ban that was imposed by Astor nation, it is the sites under Appendix 1 that list the endangered species royal mackerel, but also it provided that this royal mackerel cannot be traded, but it can be traded under some exceptional circumstances. That one of the exceptional circumstances is that the trade should save the survival of the species. And coming to relative on the trade that was conducted by Richmark, it clearly supported the survival of this species by putting some conservative efforts.
Trading.
The Convention on International Trade on Endangered Species, it has prohibited, but it allowed this trade of this endangered species royal mackerel under some exceptional circumstances. And one of the exceptional circumstances is that the trade conducted, it must save the survival of the species. Taking relative on the matter on hand, the Richmark government putting on in the importation of royal mackerel trophies from Richmark to Astor, it clearly provided some funds on the conservative efforts. So this clearly shows that it clearly supported the survival of these species.
It is the taking, not the trading.
Your Honor?
I'm saying the law allows the taking, not the trading. Did I hear you properly?
Honorable President, I'm talking on the issue number 2 of the importation of the ban of royal mackerel trophies from Richmark to Astor. And if you pass through the Convention in International Trade on Endangered Species, Appendix 1, it has listed the royal mackerel as one of the endangered species. And it has prohibited the trade of this endangered species, but it allowed the trade of this endangered species under some exceptional circumstances. And one of the exceptional circumstances is that the trade that is conducted by this nation, it should save the survival of this species. And
that's what I'm talking about. The exception is about the taking, not the trading. It is just a point of correction.
Thank you, Your Honor. Honorable President, may I go on with the submission? I'm going to go on with submission on relying on the Convention in international trade on endangered species that provides on Appendix 1, list this royal mackerel as one of the endangered species, but it prohibits this trade of this endangered species royal mackerel, but provide an exceptional circumstances of allowing the trade of this royal mackerel endangered species, that the exceptional circumstances that it should serve the survival of the species. Taking the relative on the matter on hand, the Rismark government put some conservative efforts by funding it through the trade that was conducted between Rismark and Astor on the importation of royal mackerel trophies. Programs that were laid under this agreement that they entered. Your Honorable President, I'm going to go on with my submission on the trade agreements, all the bilateral agreements that these two nations entered. Your Honorable President, by the virtue of Article 12 of the Vienna Convention, provide that, by the virtue of Article 12 of the Vienna Convention, provide that or legalize the bound of two nations to agreements through appending a signature on the letters of agreement. Taking the matter on hand, in 2003, these two nations, Astor and Rismark, they appended a signature on the ATRA agreement, simply known as the Astor and Rismark Trade Agreement. Through this appending a signature on this agreement, they clearly adhered on the World Trade Organization that calls upon these states to clearly protect or to clearly treat the foreign products equally to the domestic products that are in their country. Your Honorable President, this provision is pursuant to Article 3 of the GATT, or the General Agreement on Trade and Tariffs of 1947. Your Honorable President, taking the matter on hand, the Rismark government, the Astor government putting a ban on the importation of royal mackerel trophies, it clearly violated the products that were from Rismark. So this ban that was imposed by the Astor government over the Rismark government on the importation of royal mackerel trophies clearly violated the World Trade Organization under the principle of the national treatment principle, which is pursuant to Article 3 of the GATT, simply known as the General Agreement on the Trade and Tariffs of 1947. Honorable President, I'm going to go on with the submission on the scientific basis. Honorable President, by taking the virtue of Article 5 of the World Trade Organization, simply emphasize on the application of sanitary and phytosanitary measures for any nation to put restrictive measures on action done by the other nation. Your Honorable President.
Agent, if on this issue, can we focus on the exceptions on Article 20, please? Because I believe that Astor has conceded that their trophy ban is a violation of Article 11. So I think the real question is whether the exceptions under Article 20 apply. Can you focus on your argument on Article 20A and Article 20G, please?
Honorable President, clearly I'm focusing on the Article 20 of the ATRA and Rismark Trade Agreement, but keeping my focus on this matter on hand, I just divided my submission on different bases. And one of the bases, the scientific basis. Coming to the matter on hand, the Astor government, it kept a ban on the importation of royal mackerel trophies by adhering that the trade that was conducted by Rismark government, it clearly threatened the survival of the species. But they did not provide a clear scientific evidence that the trade conducted by Rismark on the importation of royal mackerel trophies from Rismark to Astor clearly threatened the survival of the species. And this is pursuant to Article 5 of the World Trade Organization, which provide that for a nation to put restrictive measures, it should provide a clear scientific evidence that the action done by the other states, it clearly threatens the survival of the health of the environment or the survival of the endangered species. So, Your Honorable President, coming on the matter on hand is that the Astor government keeping a ban on the importation of Roma coal trophies from Richmond to Astor, it clearly violated this World Trade Organization under Article 5 of the World Trade Organization. And I'm going to make a clarification or reinforcing my submission on the case of USA, United States of America versus Pakistan, Malaysia, and India, which is simply known as the shrimp case. Your Honorable President, under this case of 1998, the USA imposed a ban on the importation of turtles from the countries that did not use turtles excluded in fishing. Your Honorable President, the relevant issue on the case is whether the ban that was imposed by USA complied or violated the international laws. Coming to the matter on hand is that from the case, the court held that the USA ban did not comply with the World Trade Organization as it did not provide a clear scientific evidence that the countries that were not using the turtle excluded clearly violated the survival of these species. So, making a relative on the matter on hand is that the ban that was imposed by Astor government over Richmark on the importation of Roma coal trophies clearly violated the World Trade Organization under Article 5. Your Honorable President, coming on the matter on hand, I'm going to make also submission on the article by the virtue of Article 26 of the Vienna Convention that provide state into a treaty or any agreement should perform the obligation of the treaty agreement in good faith. In non-compliance with this obligation, call upon a treaty to pay remedies to the nation suffered. Furthermore, the principle of the Pacta Sunt Servanda recall that once a treaty is signed, you are bounded to it unless you make reservation. Coming to the matter on hand, these two nations, Astor and Richmark, Astor did not make reservation when they entered into agreements known as the ATRA agreements in 2003, but also did not make reservation after adhering to the treaties such as the Convention in International Trade on Endangered Species. So that it did not make reservation, it is clearly that it is still bounded to the obligation of these treaties and agreement. And hence, when it comes to violate such obligation, it clearly, so when it comes and violates such obligation, this clearly shows that it has violated the Article 26 of the Vienna Convention that provides states to fully be bounded, which are bounded to trade agreement to perform their agreements or
So, Agent, you raised the shrimp turtle case.
Yes, Your Honor.
And in the shrimp turtle case, the appellate body concluded that sea turtles are exhaustible natural resources.
Yes, Your Honor.
Should we similarly conclude that royal markhors are exhaustible natural resources?
Your Honor, President, the shrimp case, it has provided the sea turtles as one of the species that were endangered. So, by just providing this, the USA imposing that ban, it clearly did not comply with the World Trade Organization and pursuant to Article 5, it did not provide a clear scientific evidence to prove that the trade the ban that was conducted or the trade that was conducted by this other nation, it threatened the survival of these sea turtles. And making relative on the matter on hand is that the Richmark government putting or conducting this importation of Roma coal trophies to Astor, it conserved the environment. So it conserved the environment as first, it went hand with hand by providing a scientific evidence on providing just 10 royal macaws to be hunted annually, and it was known as the street quotas. So, coming to the matter of hand, the Astor government not providing clear scientific evidence that the importation of royal macaw trophies to Astor from Bismarck clearly threaten survival of these species, make the ban that was imposed by Astor violate the World Trade Organization pursuant to Article 5.
So in the shrimp turtle case, the way the appellate body analyzed the issue was first they took a look at the enumerated exception under 20G, and they concluded that sea turtles were exhaustible natural resources. And then they moved up and found that the United States did not comply with the chapeau, with the introductory clause. So I just want to focus on Article 20G, though, for our purposes. So do you concede that royal macaws are exhaustible natural resources?
Your Honorable President, I agree with that.
So then what does the phrase exhaustible natural resources in the ARTA mean?
Your Honorable President, by the virtue of Article 20, paragraph G's, it calls upon the state members of the ARTA agreement, which are Astor and Bismarck, to protect the endangered species by making sure that by making sure that the measures that they enforce are not arbitrary to the restriction of international trade into the relate on the conservative measures. So, Your Honorable President, by making relative on the matter on hand, the Bismarck government conducting in this importation of royal macaw trophies from Bismarck to Astor, it complied with the obligation of the ARTA agreement, as it provided conservative efforts by funding these conservative efforts by taking the funds that were obtained from the trade that was conducted between Bismarck and Astor on the importation of royal macaw trophies. Honorable President, I continue with my submission. By that, I have already explained on the Astor and Bismarck trade agreements, which it was by the virtue of Article 20G. Your Honorable President, Article 34 of the Statute of International Court of Justice provide that a state should provide that it is affected by the matter on hand so as to have a legal stance right before the International Court of Justice. The Astor government did not provide evidence that it was affected by the trade that was conducted by Bismarck on the importation of royal macaw trophies from Bismarck to Astor. Therefore, I come this honorable court, concluding on deliberation on the matter on hand, on this court having jurisdiction on the matter on hand, and on relying on the mission done by the respondent side, clearly shows that the action done by the Bismarck government complies with international laws, but the ban imposed by Astor over Bismarck on the importation of royal macaw trophies violates the international laws.
Thank you very much. According to my discretion, I add a few minutes for questions from the bench. Okay. Do you have any questions? I have a few questions to ask.
Sure.
To whom was the right to hunt reserved?
Your Honorable President, the right to hunt was reserved to the indigenous people known as the Deongishu in the Bismarck.
To
Deongishu, an indigenous community in the Bismarck state.
Deongishu.
Yes, Your Honor.
Are these foreigners Deongishu?
The foreigners are not Deongishu.
Okay, are not Deongishu. But the instrument allowed whom?
It allowed the Deongishu community.
Okay, if that is the case, And you are the one who ratified this instrument, isn't it?
Yes, Your Honor.
And will you agree with us that this instrument which you mentioned is a guiding instrument and binding to you?
It is binding to us.
It is binding to you. Where did you get your authority now? From which instrument did you get your authority to auction that right of hunting? From which instrument?
Your Humble President, making or answering the question that you asked, is that the Richmond government got that right of actioning.
I'm asking about instrument. Just to mention instrument. From which instrument?
Article 26 of the United Declaration on the Rights of the Indigenous Peoples.
Okay. We are speaking about this particular instrument. Did that mention about this down Ginzu?
Your Honorable President, is it to provide the rights of the indigenous people, the Diogishu?
Which one is specific between the one you have mentioned now and the previous one? Which one is the specific instrument?
The specific instrument that will provide the right of the Diogishu is the United Declaration on Indigenous Peoples.
So, which instrument was required to give you the authority?
Your Honorable President, the authority that the Richmond government used to action, or that the Diogishu community used to action their rights, they used the right that they were granted in the United Declaration on Indigenous Peoples. Article 26 that...
Will you agree with me that this has been specific to that particular tribe?
It is specific to the particular...
In your bilateral treat?
In the bilateral treat, yes, it is specific to the particular tribe,
slowly. Specific to?
Particular tribe by the some exceptions.
To the particular tribe?
Yes.
Okay. If that is the case, is there any provision in that instrument which allowed you to auction?
It's by the virtue of Article 26.
Of that bilateral treaty?
No, of the United Declaration on...
I'm speaking about this bilateral treaty. Is there any provision which allowed you?
Your Honorable President, there is on the bilateral treaty, which is the ATRA agreement, call upon this Astor and Bismarck, a Storange state, to conserve the environment so as to save the survival of this species. So,
did you understand the question? Is there any provision in this specific instrument?
Your Honorable President, there is.
There is?
Yes.
May you read it? Which provision?
Your Honorable President,
on that particular bilateral.
Your Honorable President, the relevant of the portion of the ATRA provide as follows. Your Honorable President, there is a part that talks that undertake of each proceeds in a manner that is consistent with environmental protection and conservation. That is the ATRA agreement provides that. Undertake...
Okay, I think you failed to answer that question. Let me ask you another question. You are speaking about exceptional circumstances.
Yes, Your Honor.
Under which these indigenous were allowed to hunt, isn't it?
The exceptional circumstances.
Yes. But you didn't mention any exceptional circumstance. My first question, were these indigenous incapacitated of hunting?
Your Honorable President, they were.
They were incapacitated?
Yes. But after the action of their rights, they did not continue hunting.
Yeah?
But after the action of the rights, they did not continue hunting.
Before auctioning, were they not able to hunt?
Before auctioning, they were able to hunt.
They were able to hunt.
Under strict quotas.
They were able to?
Hunt under strict quotas.
To hunt. Okay, they were able to hunt. Now, which exceptional circumstance now which necessitated them to adapt or to auction if they were capable of hunting as they were allowed by the law? Which exceptional circumstance now to warrant that auctioning?
Your Humble President, as I was engaged in the second issue of whether the ban of the importation of Roma court trophies complies or violates with the international laws, the exceptional circumstances that I provided is that the trade conducted between these two nations should save the survival of the species. And I did not provide exceptional circumstances on the hunting of the Roma court trophies by the indigenous people.
Is there, but in your presentation, you didn't bring us exceptional circumstances which could convince us that there was exceptional circumstances, and you are required to stick or to focus on those particular exceptions which you thought could be relevant. Okay, thank you for your submission.
Thank you, Your Honor.
Sorry. One question, depending on how you answer. So let's say, on one hand, the convention, the CMS, is it CMS, which prohibits the taking of endangered species?
I provided on cities.
Yeah, okay. So let's say on one hand, this convention prohibits the taking of the species, and on the other hand, the ARTA, the trade agreement, promotes trade. So if there is a conflict between the two, which one should prevail?
Honorable President, will you pardon? Pardon?
On one hand, the convention, you say the sites.
It's cities, yes. Cities.
It prohibits the taking of endangered species.
It prohibits
right?
The trade.
The taking.
Yes.
On the other hand, the ARTA, the trade agreement between the two countries.
Yes.
It promotes trade between these two countries.
Yes.
So, in case of conflict, let's say the trade agreement contravene the convention, which one should prevail?
The trade agreement does not contravene the convention, but it complies.
Yes?
The trade agreements does not contravene the convictions, but it complies as the conviction provide on the two nations to provide the trades that are adhered to supporting the survival of these species. And looking this trade that...
Okay, let's assume.
Yes, Your Honor.
Assume the trade agreement contravene the convention. Which one will prevail?
The trade agreements and the convention.
But for the agreement to be valid, it has to be legal, lawful.
The agreement that is between these two nations is legal lawful.
Yes.
It is legal lawful. It was signed by these two nations in 2003 and taken by the virtue of Article 12 of the Vienna Convention bounds the states to trade agreement if they append a signature on the letters of agreements. In 2003, these two nations, they entered and appended a signature on the ARTA agreement. So they bounded them.
Okay, so the trade agreement will prevail over the convention?
Yes, Your Honor.
Okay. Your country is complaining that ASTO is interfering with your sovereignty, right?
Yes.
But you are complaining. ASTO imposed the ban in their country, and you are complaining. Don't you see that you are also interfering with their sovereignty?
Your Honorable President.
Because they are free to decide whatever they want with their country.
Your Honorable President, as these two nations, they are bounded to various conventions and agreements, and on the applicability of the principle of permanent sovereignty of natural resources, its applicability is through adherence to the international law framework, such as the sites that provide a legal mechanism for the cooperation between states sharing endangered species, requiring the countries to develop conservative strategies monitoring species population. So coming to the matter on hand, the Rishmark ban, the Astor ban that was imposed over Rishmark on the importation of Romaku trophies did not comply or did not comply on the providing such evidence that the trade which was conducted by Rishmark on the importation of Romaku trophies clearly violated or clearly threatened the survival of this Romaku trophy, Romaku that is listed in Appendix 1 of the sites. So I think I just answered your question, my honor.
Okay, thank you.
Okay. Thank you for your nice presentation. Any comment? Anything else? Anything else? Okay. You may have your seat.
Thank you. Much obliged.
This is the end of this session. I was sharing something with my colleague there. Do you have any rebuttal? However, you didn't, it was not scheduled when you were starting presenting. And in your rebuttal, please don't repeat what you submitted. Okay? In your rebuttal, you may submit on a point where you were shaken maybe by the respondent. Not everything. Don't start afresh. I give you 2 minutes.
Yes, Your Honor. As it may please Your Lordship and Your Ladyship, it is briefly a rebuttal as to what has been submitted by the respondent. First, it is pertinent legal principle that you cannot claim for the principle of permanent sovereignty over natural resources if the same property is shared by two territories. The royal marcos are shared between the state of Astor and also by the state of Rishmark. So you cannot claim over the principle of permanent sovereignty while this species is shared by these two states. Also, there is the principle of Pancta Sunta Selvanda, which require that the countries shall be bound by what they have agreed. In the trade agreement that was entered between Astor and Rishmark, justifies our prayers before this honorable court. So also it rebuts on the issue of the permanent sovereignty of natural resources. But again, with due respect to the counsel for the respondent who escaped the class of legal method on interpretation of the provisions of the law, as they were ignorant of the fact that the provision is not merely read blindly, lifting aside the proviso of the provision. So the respondents, they were interpreting the provisions of Article 5 sub 3, of Article 3 sub 5 of the CMS, while lifting aside the proviso which provide to the extent that such exception are precise as to the content, limited in space and time, such as taking should not operate to the disadvantage of the speech. So when you read the provision of the law, you must as well consider the proviso of that provision.
Okay, thank you. This marks the end of this session. I would like to invite Mr. Benedict. You're welcome.
Okay, thank you, Honorable Judge. This, as said, it marks the end of this multi-court competition on this final round. We congratulate all the parties for their endeavor submissions, for their serious submissions. According to the timetable, we have to break for lunch. But before that, I and the honorable judges will use some few minutes in your presence to compile the marks. Each judge had a separate form in which he were making separate assessment. Now we are going to compile quickly. We are so as when we leave here for lunch, we will have already compiled the marks, but they will remain confidential between I and the judges until the time reaches for pronouncing the results. But what is just going to be done is to compile the marks. Thank you. So remain calm while we are compiling. We will leave the room or the courtroom after we have already compiled the marks. Don't go out. Please remain.